medium-sized business owner, do I really need a lawyer if I'm not being sued? In the first part of my video response to this question, I went over a half dozen reasons you might need a lawyer as a small business owner, outside of obvious matters like you're being sued or your business is the subject of a criminal investigation. In today's video, part 2, and in part 3, which is coming up next, I want to address the flip side of that answer and go over a few instances where you might think you need a lawyer and the law firm you're working with might try to upsell you additional services, but I want you to at least consider whether you can handle the matter yourself. Today, I'm going to focus only on the corporate entity formation and registration process because there's so much at this stage that can be handled by the client independently. Then, in my next video, I'll go through everything else. And I'll caveat this list by saying that if your lawyer offers to handle any of these items for you, they aren't necessarily trying to rip you off or screw you over. Some clients prefer to push everything they possibly can onto their attorney because they don't want to deal with the hassle, they can afford it, and the attorney ought to be more likely to get it done right. Having your lawyer handle everything, even if you're perfectly capable of handling some components of the work yourself, has similar advantages as assigning multiple related projects to a single capable member of your internal team does, better ensuring the consistency, organization, and efficiency of each component and the overall result. Now, with that said, if you're asking, do I really need a lawyer? I'm assuming your budget is tight. So let's talk about which parts of starting up your company you might be able to handle all by yourself. Initial registration and formation, entity formation. Most states make it extremely easy to create and register a corporate entity electronically through the Secretary of State website. In Georgia, for example, it takes my average client 5 to 10 minutes max to complete an initial entity registration by themselves. At a law firm, they would have been charged upwards of $400 or $500 for this alone, just based on the lawyer getting the information from the client, then the lawyer giving that information to the paralegal, then the paralegal completing the registration, then providing the confirmation to the attorney, who then provides it to the client. This is unnecessary and borderline absurd. Next, the Federal Tax ID or EIN. Filing for a federal tax ID for your business, your employer identification number known as an EIN, is equally straightforward, but it could end up being another hour or more of charges if you ask your attorney, who's probably just going to push it down to a paralegal, to handle it. There may be 1 or 2 questions in the application that aren't totally intuitive, but the IRS provides pop-up bubbles with explanations, or you can ask your lawyer or CPA for one-off answers if you truly can't figure out what the IRS wants. Then there are local licenses. It's the same thing with handling local licenses, DBA applications, permits, and so forth. These are annoying, of course, but they require your signature and all your information anyway, and adding a lawyer to the mix generally only adds expenses and unnecessary delays. Ongoing registrations and filings. Now let's discuss annual registrations, registered agents, and FinCEN filings. These are 3 distinct requirements requiring ongoing attention, but which are just an extension of the entity formation process I just discussed. So for annual registrations, if you've managed to form your entity through the Secretary of State website by yourself, you will have no problem with filing the annual registration as well. In most jurisdictions, you literally just click a link, confirm your information, and pay a fee. It'll take you 3 minutes to do it yourself, but the meter is running every second your lawyer or her paralegal spent discussing it or completing it or emailing you about it, and that winds up being far more than 3 minutes of billable time. Or the firm might charge you a flat fee that is way disproportionate to time spent, since it's an easy cash cow for them. For registered agents, having a registered agent really just means having an in-state address to receive state government communications and service of process in the event your company is sued. That's it. Your law firm is charging you a few $100s a year for this, not because they're adding value beyond collecting your business's junk mail, but because they can get away with it. If you don't want to list your home or office address for privacy reasons, get a UPS store mailbox or a similar street address and list yourself as the registered agent there. That's an extra $400 a year that you can spend on something useful. Now, the exception to this is if you're physically located out of state. Let's say you live in California, but you want to register in Delaware. That's out of scope for today, but ask your attorney for a referral to a registered agent service or just do an internet search for that. FinCEN filings. So finally, in addition to the annual state level registrations, most small businesses will be required to file a beneficial ownership information report with the federal government via the FinCEN website. Much like the registered agent services, this has become a cash grab for many law firms and an irresponsible one at that. As a rule, they will only take care of your initial filing and you will be responsible for all future updates to your information, which means you're going to need to figure out how to use the system yourself eventually anyway. They'll have you forward your highly sensitive personal information, things like copies of your driver's license and your social security number, and not all of these firms are particularly concerned about the privacy and security of data transmission and storage. And then they just type in the info for you. There's really not any meaningful legal analysis or insight or other value at all being added here. They're taking care of an admin task for you. Again, usually just on a one-off basis, notwithstanding that you will be subject to ongoing reporting requirements. And they're charging you a premium for it. Don't let your lawyer intimidate you into paying their firm to handle this. FinCEN does stand for Financial Crimes Enforcement Network, which is a bureau of the Federal Treasury Department, but it's nothing to be scared of. The government set up this website so that any business owner or representative can use it, no law degree required. Corporate governing documentation. Finally, regardless of your entity's size and structure, you'll need to create some basic corporate governing documentation. For an LLC, this means an operating agreement, and for a corporation, this means corporate bylaws and possibly a shareholders agreement if you have multiple owners. Even single owner entities should have this paperwork, as you'll be asked to present it before opening a company bank account, signing a commercial lease, borrowing money, applying for women or minority-owned or veteran-owned business status, and more. So for single owner entities, if you are the only owner of your company, while it's my preference that you let me create a very simple set of bylaws or a basic single member operating agreement for you to use, it's usually not the end of the world if you use a form you found online. Just please be sure that you connect with a lawyer to properly amend and restate that document before you take on a new partner, investor, or co-owner. Also, if you're a single member entity making a special tax election, for example, you're a single member LLC treated as a disregarded entity by default, but your CPA has advised you to make an S election, you'll want to ensure your governing documentation appropriately addresses this. But for single owner companies who are just going to stuff the operating agreement into a drawer after the bank account is opened, it's not best practices, but I do understand why clients prefer to use the internet resources to do it themselves for free. Now, for entities with 2 or more owners, please take the time to have an attorney draft an appropriate operating agreement or shareholders agreement that reflects your real intentions and agreements. I've lost track of the number of times business partners have yanked some garbage agreement from the internet and then later had an intractable dispute. One of the parties pulls the old nonsense operating agreement out of a drawer, which is of course binding on the parties and governs their business relationships, and then finds the provision that benefits his position, even though neither party actually thought it through in advance, and neither of them would have agreed to it if they had. Or the 2 original partners get along, but they take on a third, more sophisticated partner who realizes what this nonsense operating agreement actually means and realizes that both the original partners don't, and eventually uses it to wrest control of their company from them. Or so many other ways this can go wrong. If you're a multi-member LLC, a partnership, or other closely held company with multiple owners, please take the money you've saved from handling all the registrations, filings, and legal adjacent admin work yourself and spend it on getting the right operational and governing documents in place from day one. Okay, that's enough for today. I hope you're encouraged to explore the online resources of your local, state, and federal governments and to consider mitigating legal costs by handling some of the registrations and filings yourself. Of course, if you're confused or overwhelmed, your attorney will always be there to help you take over the process. All right, stay tuned for part 3 of this question where I'll discuss other legal and legal adjacent items that you might be able to handle independently as your business gets rolling. Business owners. Do you prefer to handle your registrations and filings independently or to have your attorney do them for you? And why?